and warm good evening to all my brothers and sisters of Bharat. At the outset, I thank Taxmann and the team Taxmann for giving this wonderful opportunity to speak on the GST litigation challenges in recent challenges in GST. I have been given 4 topics. Before I go into those topics, as a food for thought, today it may be at appellate stage or maybe at adjudication stage or maybe at the High Court level or maybe at any forum, more than 60% or maybe more than that litigation is pending with respect to input tax credit. And all other issues may be remaining issues in that. There are more complex situations like what is supply, what is place of supply, and what is valuation. But still, the input tax credit is becoming the more challenging day by day. Maybe the stringent provisions which are contained in the CGST Act and other allied laws, or maybe the business entities are not following those procedures, or maybe the government is with the intention to make more revenue, the system is running like this, and we are facing a lot of challenges with input tax credit only. Coming to the topics allotted to me. Today, I'll be dealing with 4 topics for the next 1 hour time. They are comparing input tax credit with respect to GSTR 2A and 3B. Denial of ITC when the supplier's registration is cancelled with retrospective effect. The time limit for availing the input tax credit of the previous financial year, that is Section 16, subsection 4 of the CGST Act, and the challenges faced by the taxable person regarding the cross-empowerment in our country. So let us go into this each subject, and then we will discuss on the provisions of the law, then what are the recommendations of the council wherever it is applicable, and what are the case laws or the citations which are available to come out of the situation, and what are the challenges with respect to those things we will discuss. Coming to the first point, that is comparing input tax credit between GSTR 2A and GSTR 3B. Initially, when in 2017, when the law was introduced, there was a system of GSTR 1, GSTR 2, and GSTR 3. And then after filing GSTR 1 by the supplier, the data in GSTR 1A was planned to go to recipient. Then any amendment made by the recipient that will communicated to the supplier in GSTR 2A, and finally GSTR 3 return need to be filed. But of late, that has never happened. And in place of GSTR 3 and all this process, GSTR 1 and GSTR 3B have been introduced by the law. What the GSTR 2A we are talking today is something different from the what initially which was planned actually. Let us look into what the GSTR 2A, what actually we are talking about this. GSTR 2A is a dynamic form. So day in and out, whenever the supplier makes the changes or amendments in GSTR 1, that will be reflected in GSTR 2A of the recipient. And the recipient has to check this data on monthly basis while filing the GSTR 3B returns, and also while filing GSTR 9 return, what is the data available in GSTR 2A, and he has to compare. Initially, when the law was introduced, they said 20% of the ITC provisionally, which is not appearing in GSTR 2A, will be allowed to you. Later on, it has been reduced to 10%. Thereafter, it has been made to 5%. Now, GSTR 2A is introduced into the statute. Thereafter, now at presently, GSTR 2B, whatever the GSTR 2B, the input is available in that return, that only has to be taken by the recipient, provided he is eligible for the input tax credit. It may happen that the supplier, instead of keying the data of B2B transactions as B2C transactions, or maybe he has wrongly keyed in the data of sales or supplies, or maybe possible that he has not reported those transactions. Though the recipient is not at mistake or not is having full availment, but because of the mistakes of the supplier, the recipient is made to wait or to request the supplier to upload his GSTR 1 properly. So for the mistakes of the recipient, for the mistakes of the supplier, the recipient is suffering a lot in this scenario. The communication between supplier and the recipient is not being established by the department. Though there is a small facility called a window is provided to communicate to the supplier by the recipient in GST portal, but that is not a foolproof and that cannot be taken as a legal stand. Let us look at section 16.2 subsection AA. Section 16.2 AA is brought into the statute by Section 109 of the Finance Act 2021, and it has been notified by Central Tax Notification 39/2021. It is brought into the statute with effect from 1st January 2022. Practically speaking, this GSTR 2A written or the format or the mechanism of communication of supplies made by the supplier to the recipient or before 1st January 2022 was not there in the statute. But if you look at Rule 60 Subrule 1, it talks about the data uploaded by the supplier is made auto-populated to the recipient in form GSTR 2A, and it was brought by amendment by Central Tax Notification 79/22 with effect from 15th October 2020. See the situation here. The rule is amended on 15th October 2020, but whereas the section has come into the statute from 1st January 2022. So between this period or before 1st January 2022, there is no concept of GSTR 2A in the statute or in the statute book. In the absence of the enabling provision in the Act, whether a rule which is brought by 79/2020 notification is valid. In my view, it is not valid, and the department or the adjudicating officer cannot insist on the recipient that your input tax credit is not appearing in GSTR 2A and you are claiming the input tax credit over and above the GSTR 2A. This stand cannot be taken. In this regard, the board has given two circulars, one circular on 27th December 2022 and another circular on 17th July 2023. This circular number 183 and 193 talks about the procedure to be followed wherever the credit is not appearing in GSTR 2A of the recipient and is eligible to take the input tax credit. In those situations, he has to follow certain procedure. That procedure prescribed is he has to obtain a certificate from the supplier or from the chartered accountant or cost accountant of the supplier stating that the tax on these invoices have been paid to the exchequer and the recipient is eligible to the input tax credit. For your notice, I say that these two circulars are issued by the GST policy wing of the CBIC. This is not being issued by the board. Whether the circular issued by the policy wing of the CBIC is valid or not, that needs to be tested. Because in the past, we have came across situations where the TRU Tax Research Unit was issued certain circulars, but the high courts have held that the Tax Research Unit cannot issue a circular and the circular is not valid. Similarly, the GST policy wing issued these two circulars, whether these will be valid or not, one has to look into that. And the circular number 183 is applicable for the year 1718 and 1819. And circular number 193 is applicable for the period 1st April 2019 to 31st December 2021, because this section is brought from 1st January 2022. So till the period 31st December 2021, any comparison between GSTR 2A and GSTR 3B, anything is not matching in between these two, then the procedure prescribed under this circular has to be followed by the recipient of the supply to claim the input tax credit by him. Let us look into the judgments of the courts in this regard, what the courts are saying. In Union of India versus Bharti Airtel Limited, 2021 judgment, 131 Taxmann.com 319, Supreme Court judgment. The Supreme Court has considered the reply, the submissions made by the appellant and also the respondent, that is Bharti Airtel Limited, and the court has concluded saying that GSTR 2A is only a facilitator for taking an informed decision while doing such self-assessment process. See, in GST under Section 59 of the CGST Act or the State GST Acts, the recipient or the person who is liable to pay the tax is required to file the GSTR return as to make a self-assessment. For the purpose of making the self-assessment, GSTR 2A is only a facilitator till the section which was brought into the statute, that is 16 subsection 2 clause AA. Till that time, it is only a facilitator as per the Supreme Court. Let us also look into the another judgment. Suncroft Energy Limited, Energy Private Limited versus Assistant Commissioner of State Tax 20. This is judgment of 2023. It is reported on 153 taxmann.com 81. This is delivered by the Calcutta High Court. The Calcutta High Court also held that the information submitted by the supplier in GSTR 1 will be auto-populated to the recipient in GSTR 2A, and there is no specific provision in the Act to say that it is legally valid. Then the Calcutta High Court also held that the facility to view the same inform GSTR 2A by the recipient is in the nature of taxpayer facilitation and does not impact the ability of the taxpayer to avail the input tax credit on self-assessment basis in consensus with the provisions of Section 16 of the Act. So Section 16 was amended with effect from 1st January 2022. Before that, this is only a facility. It cannot be insisted on the recipient for claiming of the input tax credit. Taking clue from these two judgments and the circulars issued by the GST policy wing and also the amendment of the section and the rules thereon, any difference between GSTR 2A and 3B with respect to input tax credit, now it is the responsibility or the duty of the recipient who is claiming the input tax credit. If there is any variation, say in my GSTR 2A, it's appearing 10 lakhs and I'm eligible only for 9 lakhs. I have claimed 9 lakhs. In this situation, there is no argument or the demand made by the department. Whereas if the situation is vice versa, then the claim 2A is consisting of 9 lakhs and the supplier's balance is, the 3B input claimed is 10 lakhs. In that situation only, the recipient has to verify his records. What are the invoices which are not appearing in GSTR 2A, which are compared to what is eligible to claim. So for those 1 lakh of input tax credit, he need to go back to the supplier and obtain the certificate, and that certificate has to be produced before the adjudicating officer or the investigating officer whenever the situation warrants. Next question, which we are going to deal is denial of input tax credit when the supplier's registration cancelled with retrospective effect. Friends, I think you have remembered that during July 2023, from May 2023 to July 2023, the department has conducted nationwide survey for the registrations. Wherever they find that premises is locked and the person is not traceable or person is not present, and for various reasons, the department has cancelled the registrations of the suppliers or the registered person with retrospective effect, maybe going back to the original date of 1st July 2007. In this situation, what department is doing that? The supplier's registration is cancelled with retrospective effect, and you have claimed, that is the recipient has claimed the input tax credit of those specific suppliers, and the department is giving a demand notice, maybe in the form of show cause notice or a letter, and saying that this input tax credit, you are not eligible from these cancelled registrations, and you pay the tax input tax credit along with the interest. In this situation, to answer this question, let us look into the legal provisions, statutory provisions relating to this aspect. Section 16, subsection 1 and subsection 2 gives us the right or the facilitation to claim the input tax credit. In these two subsections, subsection 1 talks about every registered person, that is a recipient must be a registered person, and this condition specified in subsection 2 have to be fulfilled by the recipient to claim the input tax credit. So in these conditions, maybe subsection 2, subclause A, subclause AA, subclause B, subclause BA, and subclause C, subclause D never say that the transaction, the date of the never say that on the date of transaction, the registration of the supplier is valid. Then subsequently, if its registration cancels, then the recipient is not entitled for the input tax credit. Nowhere in this section, law is framed like that. Maybe for whatever the reasons, the government has cancelled the registrations of the suppliers, and those on the input from those suppliers, the department is objecting for that. To answer this, we need to go into whether the department really has the power to cancel the registration retrospectively. For that, we need to go into section 29, subsection 2 of the CGST Act. This section empowers the proper officers to cancel the registration retrospectively for various reasons, such as contravention of the provisions of the law and paying tax under Section 10. He has not filed the returns beyond 3 months, and a person who is a regular dealer and who has not filed the returns beyond 6 months, and a person who has taken the voluntary registration and not commenced the business within a period of 6 months on the date of registration, and the person who has obtained the registration by means of fraud, willful misstatements of suppression of facts. In these circumstances, the proper officer is empowered to cancel the registration of the supplier or the registered person with retrospective effect. Fine. On one fine day, that is say during the month of May 2023, department has conducted survey, and in that survey, a business premises was closed, or there was no board on the premises, or maybe reasons that on that particular day the person was not available in the premises, but various reasons, maybe he is suffering with illness, or maybe otherwise he has went to tour, or whatever the reasons, yes, he was not available on that day. Because merely because of these reasons, those registrations were cancelled by the department. And the department has taken a stand that because they are doing the fraudulent activity and all these things, now we are cancelling that registration, and they have been given notices and all these things. And finally, the department has cancelled their registration. Now the department is coming back to the recipient and saying that your supplier registration was retrospectively cancelled from 1st July 2017. It was cancelled in the month of, say, May 2023, but the purchase or the transaction between the supplier and recipient, say, took place between in the year 2018-19. Say, during 2018-19, the registration of the supplier was a valid registration, and he was authorized to collect the tax and remit the tax to the exchequer. Now, what is the remedy available to the recipient for claiming input tax credit wherever the registration of the supplier is cancelled retrospectively? If you look at the couple of judgments of Calcutta High Court, in one case, LGW Industries Limited Union of India, 2022 judgment 134 Taxmann.com 142, it is held by the Calcutta High Court. The court in this case has gone into the merits of the case. They have even verified the genuineness of the transaction between the supplier and the recipient, and the department has cancelled the registration of the supplier with retrospectively effect. In this situation, the court had held that were made before the cancellation of the registration of the supplier, so the transactions are genuine, and every document which is prescribed under the law is maintained by the supplier and the recipient. In that situation, the recipient cannot be denied the input tax credit what was held in the case of LGW Industries Limited. Similarly, also in the case of Gargo Traders versus Joint Commissioner Commercial Taxes State Tax, this is a judgment of 2023, reported at 151 Taxmann.com 270. In this case, the court has went into great details of these facts of the case, and also held that the denial of the input tax credit to the recipient where the registration of the supplier was retrospectively cancelled and the transaction took place at that juncture, the registration of the supplier is valid. So the recipient is eligible to take the input tax credit that was held by this court. So friends, taking clue from this section 16 subsection 1 and 2 and also section 29 subsection 2, And the judgments of Calcutta High Court in case of LGW Industries Limited and Gargo Traders cases, one can safely conclude that even though the registration of the supplier is cancelled retrospectively, the recipient is entitled to the input tax credit before the cancellation by the department, provided all the conditions of section 16, section 16, 17, and all those things need to be complied by the recipient. Wherever he is eligible, he can take the input tax credit in this regard. To our surprise, or maybe to rescue the trade, recently in the 53rd GST Council meeting, the Council has recommended one recommendation with respect to Section 16, subsection 4. Though this recommendation directly is not linked to this, but we can draw a beautiful, suitable conclusions for the purpose of our discussion. The Council has said that the relaxation in conditions for Section 16, subsection 4 of the CGST Act, in which the second part of the recommendation says that with respect to cases where the returns has been filed after revocation. So during the drive, the department has cancelled the supplier's registration and the supplier has applied for the revocation, and the department has revoked the cancellation and this registration has become valid. From the date of valid registration, date of becoming valid registration within 30 days, even though the limitation period under Section 16, subsection 4 has been lapsed, if he files within 30 days of that revocation of cancellation, then the recipient is eligible to take the input tax credit. So this regarding is a welcome measure by the recommendation of the Council. And with this recommendation, the suitable amendment has to be made in the law, and also a suitable notification to be issued by the government in this regard. And I hopefully after a couple of days, the Finance Act 2024 is to be presented by the Madam Nirmala Sitharaman. So we are expecting that a suitable amendment is suggested in this regard. Friends, let us move to the next issue, the time limit for availing the ITC of the previous financial year. What I want to say here is Section 16, subsection 4 talks about the limitation or the time limit under which the recipient of the supply can claim the input tax credit. There are certain the dates have been prescribed. According to that date, he has to claim. Before going into Section 16, subsection 4, let us look at the Constitution of India. Article 19, subarticle 1, clause G, 19(1)G says that gives us the right to trade. And this article also specifies that in fiscal laws, there can be a reasonable restriction with respect to the right to trade. The limitation provided under Section 16, subsection 4 is a reasonable restriction or not. That is the one has to answer this question. And another part of the Constitution which we need to consider is Article 300 capital A. 300 capital A talks about the vested right. Whether under the provisions of the GST law, the claim of input tax credit or availment of input tax credit is a vested right or not. So for these two questions, let us wait for the next couple of slides to answer that question, whether 19(1)G is violated. Why is Section 16, subsection 4 is in violation of 19(1)G and Article 300A? We will answer that. Let us go into Section 16, subsection 4, what it says first. Prior to 1st October 2022, Section 16, subsection 4 was having the conditions that the previous year input tax credit has to be claimed before due date of September month return or date of furnishing of the annual return, whichever is earlier. Later, from 1st October 2022, this section has been amended by Finance Act 2022 by Section 100, and this section is notified with effect from 1st October 22 by notification number 18/22 dated 28 September 22. After the amendment, section says that the previous year input tax credit can be claimed till 30th November of the following the end of the financial year or the actual date of filing of annual return, whichever is earlier. So the difference of 40 days between these two amendments in the pre-amendment period till October 20, the time was available. After the amendment, it has been extended to 30th November. That means that September month due date is October 20th. That was the time before the amendment. Later, after the amendment, it has been made to 30th November. So there is a increase of 40 days of time limit from 1st October 2022. So that means this amendment is applicable from October 22. That means for the financial year 22-23, only this 30th November will be applicable till the 21-22. That means that in sections financial year 17-18 till 21-22, the due date or the time limit is only 20th October. Whether if I file my March month return of 2019 on 21st October 2019, the department was denying my input tax credit. That is because you have claimed your input tax credit beyond the limitation period specified under section 16 subsection 4. So many people have went into trade and a lot of people have been troubling with this provision. In one suitable notable judgment of the Kerala High Court, that is M Trade Links versus Union of India, this is a 2024 judgment. It is reported at 163 taxmann.com 218 page. The Kerala High Court said this amendment, the Kerala High Court has gone into various provisions of the law, section 39 and books of accounts and all other provisions and post-amendment, pre-amendment, all these things have been considered by the Kerala High Court, and the Kerala High Court finally made a verdict saying that this amendment being procedural in nature has to be given retrospective effect, and therefore it is provided that it should be treated that the time limit for furnishing the return for the month of September is 30th November in each financial year with effect from 1st July 2017, considering the peculiar nature of the difficulties in the initial period of implementation of the GST regime. It is a welcome judgment given by the Kerala High Court in M Trade Links case. From this judgment, what comes to our mind is for the 17-18 financial year, the limitation under 16 subsection 4 is 30th November to 2018. For 18-19, the limitation is 30th November 2019. Like that, for each and every year, the September month due date has to be considered as 30th November, not the October 20th. That is, so the limitation of that extended benefit of 40 days was made available for all the financial years till the amendment is brought into the statute. This is a welcome measure, and all those persons who were filed their returns before 30th November of those after the end of the financial year, they were all got the relief by this judgment. Let us go into further and analyze what is the status of these cases on this specific section. Various honorable high courts held section 16 subsection 4 is constitutionally valid, considering the Article 19 1G and Article 300 of the Constitution of India. So the various honorable high courts have held that this is section 16 subsection 4 is a reasonable restriction and it is not a vested right for the recipient to claim the input tax credit. This is a facility created by the GST statute, and the recipient has to undergo the rigorous of section 16, 17, all the provisions of the law. At present, more than 24 cases are pending before the Supreme Court on section 16 subsection 4 constitutional validity. To my surprise, more than lakhs of people are facing this problem across India, but only 24 cases are pending before the law. So from this, we can draw a conclusion that how much we are concerned with our rights. And we have to wait till the outcome of the Supreme Court. Till the Supreme Court's give the judgment, the Kerala High Court judgment will prevail, which was given in M Trade Links for the financial years up to 31st, financial years 21-22, the due date to be considered as 30th November. And surprisingly, the 53rd GST Council has came out with a different analogy and different interpretation, and they have came out with a most welcome provision, and this is going to give a lot of relief to the trade. As a 53rd GST Council recommendation, which were released on 22nd June 2024, it has said, in respect of initial years of implementation of GST, that is financial year 17, 18, 18, 19, 19, 20, and 2021 financial years. For these 4 financial years, the due date, the time limit under section 16, subsection 4 will be considered till the 30th November 2021. So for the financial year 17-18, the limitation is still 30th November 21. For the 18-19 also 30th November 21. For 19 and 20 also, that limitation is 30th November 2021. And for the year 2021 also, this is going to be the 30th November 2021. So a lot of relief has come by way of this recommendation, and this recommendation has to be by way of amendment in the statute, and we are expecting a suitable amendment in the statute in the next scheduled finance bill, which is going to be presented on 1st July 2024. So we should thank the GST Council and all the members of the council for taking a proactive step and giving granting a lot of relief to the persons, those who have filed their returns lately and claiming input tax credit for the years, all these 4 years, and they have got a lot of relief. We'll get a lot of relief when the statute is amended with this effect. Come to the next part of my topic. Friends, the next topic is challenges faced by the taxable person with respect to cross-empowerment. Before we go into the sections and provisions and case laws and all these things, what is cross-empowerment? Let us understand this. Cross-empowerment, as per the Constitution of India, Union has right to levy taxes on the matters mentioned in Schedule 1, Part 1, and the state has the concurrent power to levy the matters on Part 2 of the Schedule 7, and on the Part 3 matters, both the center and state have the power to enact the laws. But if you look at the GST law, where on supply of goods and services, both the center and state government have the concurrent jurisdiction, that is cross-empowerment to levy the taxes, which was paved the way by way of Constitution 101 amendment in the year 2016. So Constitution 101 amendment has paved the way for the cross-empowerment to the state and central government to levy the tax on the same subject matter, that is goods and services tax. Is that not sufficient to empower? Cross-empowerment is not so for the government. That cross-empowerment was not sufficient, and they have traveled below that. And now they said that even in the case of administration of a taxable person, they want to have the cross-empowerment. So let us look into the provision. Section 6 enables the cross-empowerment with respect to the administration and adjudication and all the provisions under the GST law. Section 6, subsection 1 gives the power to the government. Without prejudice to the provisions, I'm reading this section for the purpose of all the audience. Without prejudice to the provisions of this Act, the officers appointed under the State GST Act or the Union Territory GST Act are authorized to be the proper officer for the purpose of this Act. So similar provisions there will be there in the Union Territory Act and also the State GST Act. And there is a condition saying that subject to such conditions as the government shall, on the recommendation of the council, by notification specify. So for cross-empowerment of the taxable person or the registered person for the purpose of administration, adjudication, collection of tax and appeals, all these purposes, the government has the power to specify those conditions, and these conditions to be specified as per the recommendation of the council, what it says. Here, this section, plain reading of this section does not give the meaning saying that only where conditions are there, then that situation only the notification has to be issued. I think you are able to catch my point. For the purpose of empowerment, as per the recommendation of the council, the central government has the power to issue a notification for the purpose of cross-empowerment. In that notification, for exercising those powers, the government can put some conditions. That is what the section, this plain reading of this section. But this section does not say that only when the conditions are there, then only the notification has to be issued. This was the interpretation taken by the council in certain stage of their discussions. Let us go into the council minutes and to examine how the council want to make the cross-empowerment. In 9th council meeting of the GST Council, in its meeting on which was held on 16th January 2017, it has held that both the central and the state tax administrators shall have the power to take intelligence-based enforcement action in respect of the entire value chain. So the council has recommended this, but no notification has issued for your information. Both the central and state, that means the state intelligence officers and the DGGI will have the cross-empowerment basing on the intelligence-based information. On the space, they both have the enforcement action, they can take it. But no notification has been issued in this regard. In 22nd GST Council meeting, which was held on 6th October 2017, the Council has recommended saying that to issue notification by the central government and the state governments for cross-empowering the officers of the central and state to sanction refunds, and that an order of the refund passed by the officer of the central or state government shall cover both the central tax and the state tax. Similarly, notification to be issued under the IGST Act by the central government. So far, these are the two meetings in which the council has held that matter with respect to the cross-empowerment. Let us look into what are the notifications are issued by the government with respect to the cross-empowerment. There are two notifications are issued by the purpose of cross-empowerment. The first notification was Central Tax Notification number 39/2017, dated 13th October 2017. This notification grants cross-empowerment for the purpose of refunds. Let me stress, refunds only. And the second notification talks about, which was by way of Central Tax Notification 10/2018, dated 23 January 2018. This notification amends certain part of the notification number 13/2017. So, my dear friends, with respect to cross-empowerment under Section 6, the government so far has issued only these two notifications. Apart from these two notifications, there are no other notifications issued. That means when we read Section 6, subsection 1, where the notification has to be issued by the government, only these are the two notifications which have been issued by the government. That means for the purpose of administration, for the purpose of adjudication, for the purpose of cross-empowerment, other than refunds, there are no notification. It is very clear to understand that if I am under the administrative control of the state government, a central tax authority cannot issue a notice or cannot adjudicate me, cannot hear my appeals. So that is what is my interpretation with respect to this subject matter. But the state and central authorities, especially DGGI and the state enforcement authorities, even though the assessee under the control of the central, the state authorities are issuing the notices for the purpose of verification of records and purpose of adjudication, for the purpose of various processes under the law. If I am under the state central jurisdiction, state authorities are issuing, and if I am under the state jurisdiction, central authorities like DGGI and the anti-evasion wings of the commissionerate are issuing notices to me. Whether all these notices are valid, whether they can exercise the power of cross-empowerment in the absence of notifications, the answer is no. Let us look into the judgment of the Madras High Court. Madras High Court in case of TVL Vardhan Infrastructure versus the Special Secretary, Head of the GST Council Secretariat. This matter is relating to 2024, which is cited at 160 taxmann.com, 771 page, Madras High Court, this judgment is given. In this case, the Madras High Court has categorically examined all the provisions of the law, like Section 60, notifications, council recommendations, and all the matters relating to the cross-empowerment have been examined by the court, and the court finally said officers under the state or central tax administration, as the case may be, cannot assert the power of investigation or adjudication of any assessee who is not assigned to them. So with the verdict of this Madras High Court judgment and with the power of this judgment, now one can safely say that if I am under the control or administrative control of the state authorities, if DGGI or any authority of the central authorities issues me notice, they are not empowered. They don't have the jurisdiction to issue the notice. This, please keep in mind, this judgment is going to help us. So with these 4 topics, my session comes to end. But I want to discuss one more important aspect before the audience, for the benefit of you, where in my presentation I have cited various High Court judgments, only one or two Supreme Court judgments. When we are appearing before the authorities, they are saying that on this aspect, and a specific aspect where maybe at appellate stage or maybe at the adjudication stage, the officers are saying that the judgment is not issued by the jurisdictional High Court and not by the Supreme Court High Court. You provide us the judgment of the jurisdictional High Court such that we will adhere to it and grant you the relief. But these observations of the officers, they are not giving in writing, but orally they are saying that. I wanted to share because I encountered this situation. So I wanted to benefit my brothers and sisters who are listening to this session, and all the High Court judgment, whether they are applicable to the other parts of the country or not. That is what I wanted to share certain points on this. So I am in Telangana, Hyderabad, and the Madras High Court judgment is issued in the case of TVL Vardhan Infrastructure. Whether that case law or that judgment can I use in favor of my client or not, that is the question. The officers are bluntly saying that this is not the judgment of Telangana High Court. If you have a judgment of Telangana High Court, we are going to accept it. Otherwise, we are not going to. This is oral argument made by the officer, not in writing. So to answer this question, I wanted to share certain two aspects to your knowledge. The first one is Article 215 of the Constitution of India. It says, every High Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. The Supreme Court of India is also a court of record, and all the High Courts in India are court of records. So judgment given by the court of record, say for example, Madras High Court or the Telangana High Court, it is applicable across India. All the officers below the High Court are required to adhere to that judgment, and they have to allow or grant the relief to the person who is relying on that judgment. And I also want to share one judgment under the Supreme Court law in case of Commissioner of Income Tax versus Godavari Devi Saraf. In this case, the High Court of Bombay High Court has held that section. So the section which was challenged in the case, in this specific case, was already struck down by the other High Court. So in light of that section was already declared ultra vires by the competent High Court of the country, and an authority like an income tax tribunal acting anywhere in the country has to respect the law laid down by the High Court, though of a different state. So even the jurisdictional High Court or the home High Court is not given the judgment, still the judgment of other High Court is a valid judgment as per this judgment. It goes further and says, so long as there is no contrary decision of any other High Court on that question. So in light of this judgment, please make a note of the judgment, and although my presentation is going to be shared with you in due course of time, so please take the shelter under this judgment. Under the Article 215 say that this judgment and this article says that the High Court judgment of other High Courts other than the jurisdictional High Court is very much valid, and it needs to be adopted by the officer acting below the High Court. So this is, friends, my presentation with respect to GST litigation, recent challenges and the possible solution with respect to the GST law. And I hope it has given you a lot of insight into the subject and it is useful for you. Thank you very much for your patient listening. Thank you one and all. If there are any questions, I love to answer those to the extent my might support. There is one question in the chat box. Hi, sir. Once the appeal is filed, do we have to separately file a stay application for grant of stay? Dear friend, if you look at section 107 of the CGST law, it says that once you pre-deposit 10% of the disputed tax, and if you pay the undisputed tax, automatically 90% of the disputed tax is automatically stayed. You need not file any stay application under the GST law. Maybe under the STY law, maybe there was a situation, but when after the implementation of GST law, that stay application is not required. What about section 16, subsection 4 cases wherein the appeal is filed? Before the amendment made to the section 16, subsection 4 by the Finance Act, which is going to be presented in the budget 2024, if any appeal is filed, the benefit of that amendment can be taken and the appeal can be withdrawn, and the officers is required to grant the relief with respect to the amended law because it is going to be a retrospective amendment. This is my view on this aspect. Sir, what is the time limit for availing ITC, which is temporarily reversed in table 4B2 of the GSTR 3B? Dear friend, I am very poor in respect of tables in GSTR 3B. And I assume that this table deals with the all other reversals. Relating to all other reversals, there is no time limit. Whenever you fulfill the conditions of the law, at that time you can take whenever, maybe after 5 years, and maybe after 6 years, you can take the input tax credit reclaim. So if it is says under second proviso to section 16, subsection 2, C, that if the payment is not made to the supplier within 180 days and you have paid that, reverse the input tax credit, and now under 4.2b, then you want to reclaim is whenever you made the payment to the supplier and the month in which you made the payment to the supplier, in that month, you can claim it. Maybe it is after n number of days. Sir, what is the time limit for availing ITC, which is temporary? Okay. Next question. 2A and GST have to be disputed ITC. Appeal is filed. What is to be implication of those cases after GST? I think I have answered this question. So once the law is amended, after that, you can ask the authorities to, the appellate authority to consider this amendment and give the relief, or you can withdraw the appeal and ask the authority to, the adjudicating authority to, if it is possible for revision, or maybe under the powers granted to him, and how the government, how the notification is going to come, or how the amendment is going to come, we have to see, and then we have to look into that. Input tax credit after due amendment 16(2)AA, after the amendment of insertion of section 2, subsection 2, clause AA, which says that unless the input tax credit appears in the GSTR 2A of the recipient, ICAI is not eligible to take the input tax credit. And also there is a new amendment which is brought by way of 16(2)(b) subsection BA that says that unless it appears in GSTR 2B, you are not eligible to take the input tax credit. That is what we have to follow now, because that has been brought under this into the statute. Next question: our client has selected under section 65 selected under section 65 audit. As soon as the audit is completed, ASMT 10 is issued for verification of entire books of accounts. Is this a harassment to the taxpayer? Can ASMT 10 be issued after the audit completion? I don't know whether it is issued by the state authorities or the central authorities. When the audit is completed, and section ASMT 10 is for the purpose of scrutiny of the return, and section 65 talks about the audit. Both are different provisions and both cannot be clubbed together. And section 65 is a broader section than ASMT 10. That's a relevant section. So when section 65 proceedings are being conducted by the authority, the matter relating to ASMT 10 is already covered under the audit. In that situation, ASMT 10 is not warranted. Even if the authority has issued that ASMT 10, you can safely say that the under audit under section 65, this matter has already been considered by the audit officer, and this point has been clarified, or accordingly tax has been paid on this aspect. Then you can safely reply to that notice, and the officer is bound to drop that notice.